you don't mind, I'm just going to step over, give Mr. Pearsall a heads up that this is running now.
Okey doke.
Thank you.
Okay. I'm just going to wait till he comes back to just officially announce it.
Yep.
Ms. Crowley, to the extent that this helps, this is Kendra Berardi. I will be opening for the plaintiff.
Okay.
Ms. Long will examine Mr. Cook, who will be our first witness, and then I will examine Mr. Turner, who is our second witness.
Perfect. Thank you.
You're welcome.
Okay, we ready to go?
Okay, so this is case number 19 miscellaneous 89 ASD 3 Rivers MA Solar LLC versus the Planning Board of the Town of Wilbraham.
Good morning, everybody. We are going to swear the court reporter. I'm going to, and well, there you are. You moved your position. Hi. And then we're going to get started. So let me just do that, and we'll begin. Do you solemnly swear to honestly and accurately record the testimony in the matter now in trial?
I do.
Thank you. So a couple of just sort of housekeeping issues in terms of Zoom. We're trying this out now. We're live on YouTube. So it's real important that everybody speaks one at a time and not on top of each other, because otherwise the reporter's not going to be able to keep track of things. So I think we're ready to go. If we want to take a break, if anybody needs to take a break, just raise your hand, let me know. We can pause. And when we do take a break, I'm going to ask you, we'll still be, in order to make it as simple as possible, I'm just going to ask you, if you can see in the bottom left-hand parts of your screen, you can stop your video. And, no, see if I can get it to go again. Okay. There, whoa, I'm having a hard time with it now. There we are. And then, so when we take a break, stop your video, mute yourself, and then we can just go away, and we're going to leave the whole system running so that we don't have to reboot the whole thing when we start up again. So, okay. Super. Okay, I think we begin with opening statements. We agreed on brief opening statements by each party. Why don't counsel needs to introduce themselves? We didn't do that yet. So let's do that. Begin with plaintiff's counsel, please.
Good morning, Your Honor. Kendra Berardi for the plaintiff.
Good morning, Your Honor. Danielle Long, also for the plaintiff.
And do you want to just explain who's in the room with you today, just for the sake of the record and for clarity?
Sure. We are joined today by Mr. Evan Turner and Mr. Lawrence Cook, both of whom are witnesses for the plaintiff.
Thank you. And when they testify, they're going to go into a separate room by themselves, right? That's
correct.
Correct.
Super. And Attorney Marshall, you figured out where Mr. Pearsall is. He's watching on YouTube now. Is that the situation?
Yes, he's in a separate room by himself across the hall.
Okay. Do you want to introduce yourself for the record, please?
Attorney Alan Marshall for the defendants, Planning Board of Wilbraham.
Okay, thank you. So opening statements, plaintiff's statement first.
If you'll bear with me, Your Honor, I have to stand.
That seems like a good idea.
My muscle memory will not allow me to do this seated. Good morning, Your Honor. We're here today because the defendant denied a special permit to the plaintiff for the installation and operation of a large-scale ground-mounted solar energy system at 285 Three Rivers Road in Wilbraham, Massachusetts. And when all the evidence is in, it will be clear to this court that the denial was the very definition of arbitrary, capricious, and legally untenable. The town of Wilbraham has a bylaw section that is specifically applicable to large-scale ground-mounted solar energy systems. That bylaw section has 15 different design requirements and performance standards. And as this court will hear shortly, the plaintiff's application met or exceeded each and every one of them. Nevertheless, the defendant board purported to deny the plaintiff's application because the size, scale, and character of the proposed facility was not, in their view, suitable for the neighborhood. The evidence presented to this court will clearly establish that any concerns regarding the potential impact of this project are without merit or have already been adequately mitigated. In fact, the plaintiff submitted evidence to the board that established that the proposed facility would be more than substantially shielded from view from abutting or nearby properties and would be visually consistent and in character with the surrounding areas. And the evidence will clearly establish that in order to justify the denial of a facility that wholly complied with the requirements of the bylaw, the board reached for a reason and settled on a bylaw provision that even the board did not believe applied to this project, one related to lot coverage. As the court will hear shortly, despite lot coverage featuring prominently in the board's denial of this permit, the board never mentioned this requirement to the plaintiff before the denial was written. As the court will hear, this omission was particularly glaring in light of the fact that the plaintiff twice submitted revised plans reducing the footprint of and increasing the setbacks for the proposed facility. Despite these good faith reductions designed to address the board's stated general concerns regarding size, the board failed to mention any possible lot coverage requirement that would later apply. Even worse, the evidence will establish that the board never considered lot coverage for any of the other three large-scale ground-mounted solar energy systems that have already been allowed in the town of Wilbraham. And that when the board finally performed this analysis of lot coverage, it was clear that a facility that had already been approved by the board on BB Road had completely failed to comply. And worst yet, the evidence will show that the board then asked this BB Road applicant to develop a new methodology for lot coverage that would allow the board to determine that the previously granted BB Road application met the requirement, but that the plaintiff's application did not. As the court will hear, it is this methodology that the board is using now, a methodology that was not developed until nearly 6 months after the denial of this application, and that the board subcontracted out to a biased and self-interested party. This methodology was not shared with the plaintiff, indeed, until this past July in the discovery in this litigation, over 1.5 years after the board denied the plaintiff's permit. And despite all of this, Your Honor, the court will hear testimony that establishes that using this methodology, exactly the way it was computed by the board's chosen subcontractor, the facility proposed by the plaintiff clearly complies with the lot coverage provision the board now claims applies to this application. Finally, this court will hear from Mark Tyberski, a licensed and experienced real estate appraiser. Mr. Tyberski will testify that there is simply no evidence to support the board's claim that the proposed facility will have a negative impact on property values in the surrounding area. In short, the testimony in this case, including the testimony of the board's own representative, will show that each of the board's stated reasons for denial was merely a pretext. In fact, the evidence will show that what the board tried to disguise as 4 or 5 reasons for denial is actually just one. The board simply didn't like this project. And that, Your Honor, just isn't a lawful reason to deny a special permit. Thank you.
Marshall.
Morning, Your Honor. As plaintiff's counsel had stated, there is a specific section of the Wilbraham town bylaws related to ground-mounted solar energy systems, such as the one in question. There are objective criteria listed under that section 10, objective measurements that can be done, and they represent minimum requirements. The town bylaws specifically designate that a special permit will be required for all ground-mounted solar energy systems like the plaintiff's design. Under the Section 13 of the Town of Wilbraham bylaws, there are required findings for the granting of any special permit. Those required findings include that the proposed use is in harmony with the general purpose intent of the bylaws. The proposed use is suitably located in the neighborhood in which it's proposed. The proposed use is reasonably compatible with the character and scale. These are subjective criteria. The evidence will show at the conclusion of the defendant's case in chief that the town received evidence on criteria related both to Section 10, specific to ground-mounted solar energy systems, and Section 13, the requirements for issuing of a special permit, that went to density issues, that went to the size, the scale, the proximity of adjacent homes, the inadequacy of the proposed screening, the amount of tree clearing that would be done on this rural lot, and also importantly, the history of both the bylaws in the town and this proposed lot in the neighborhood in which it's situated. You'll hear testimony from John Pearsall, who's been planning director for the town of Wilbraham for well over 3 decades, about the evolution of this neighborhood as a residential neighborhood, how close this particular lot, though it does conceitedly meet setback requirements, the minimum dimensional requirements of Section 10 of the bylaw, simply wasn't in harmony with this neighborhood, simply was not adequate, reasonably compatible with the character and scale of other uses. So the court will hear testimony on each of these criteria, including topography of the subject lot and adjacent lots, which the court will see herself as we do our site visit on October 1st, and also on one last criteria, impact on property value. So during the public hearings in this matter, of which there were 3, the board took credible evidence of the negative impact of each of those criteria. The board reasonably considered each of those criteria. The board cited to the proper criteria as listed in the bylaws, and the board rendered its decision. As plaintiff's counsel has mentioned during her opening, there are 3 other solar energy, ground-mounted solar energy projects that have been approved by the same planning board, have been granted special permits in residential zones through the same special permit process, because they were demonstrably different, as we will show, as far as proximity to neighboring homes, character of the neighborhoods involved there. The town of Wilbraham is simply not biased against solar energy projects, and is simply not in any way biased against this plaintiff. It simply was the one out of the 4 projects that have come before this board thus far that simply didn't fit into the bylaw criteria. Thank you.
Thank you all. And yes, we did talk about a view, and we're going to do that on October 1st, which is Thursday. So I will have an opportunity to actually see the land at that time. Before we get into the evidence, I want to just review what I have in front of me, because counsel did supply binders with exhibits in them, and I want to just make sure we review what those are. So I have 27 agreed upon exhibits in 2 binders. Is that correct? Everybody's in agreement with that?
Correct, Your Honor.
Attorney Marshall, you
Yes.
concur? Yeah, so, and then there's a couple of other additional documents at the back of the binders, and those we will deal with during rebuttal, cross-examination, something of that nature. They're not now admitted into evidence.
That is also correct.
That's correct, Your Honor.
So, Ms. Crowley, are you going to mark these exhibits? We should have talked about this when we were doing some housekeeping, but you're going to mark one set of exhibits that will become the actual trial exhibits for this case, correct?
Yeah, someone has to send them to me. If they send them to me in PDF, I can just do electronic copies for everybody. with a sticker, an official sticker on them, or they can send me a binder and I'll mark the whole binder and keep them. It's up to how the attorneys want to do it.
Okay, so you don't have an actual binder in front
No
of
one
you?
sent me anything, but if you, I mean, the easiest way, honestly, is if they just send me a PDF of everything they're using, and I'll go through and I'll put an electronic sticker on them. Save them the shipping of the exhibits to me, and everybody would have a copy with the exhibits.
The thing that is a little tricky about that is that the court needs an official set of trial exhibits with stickers on it. And if they're electronic, then they have to be printed out.
Printed. Okay.
So I think we need a hard copy, if you don't
Okay.
mind. Can somebody ship those to you and you ship them back? Would you be
Yep.
able to file the final trial exhibits when you file your transcript with the?
Yep. I can definitely do that. Yep.
Okay, can somebody willing to ship a set of these binders out to Ms. Crowley?
Yes, we can take care of that. And I actually have, I know we talked about this before, the original exhibits with my original stickers that aren't even in a binder because I don't know if you want the holes.
Right. Yep,
We can send that as a package and we can send that out tonight before we leave.
Perfect. Yep.
Okay, so that's great. So thank you. And also in the, there were some stipulations that were agreed to in the joint pretrial memorandum. There were 26 agreed statements of fact, and I just want to make sure that all counsel are in agreement that I'm going to be taking those as agreed upon stipulations as evidence in this case.
Yes, Your Honor.
Yes, Ron.
Okay, super. And then the last thing before we dive into the evidence, I just wanted to review one more time what the issue is that's before me. I think we identified 2 issues at the pretrial conference, and I'm just going to identify those and have them part of these proceedings. So the first question is whether the defendant's denial of plaintiff's application for a special permit and site plan review was arbitrary and capricious and or in excess of the board's authority under Chapter 40A, Section 17. The second issue is whether the defendant's denial was an unreasonable regulation of the installation of solar energy systems or building structures that facilitate the collection of solar energy in violation of Chapter 40A, Section 3 and Section 17. So those are the 2 issues, and I think we're all in agreement with those, but I just would like to get your confirmation before the evidence begins.
Yes, Your Honor.
Yes, Your Honor.
Okay, so I think with that, we are ready to go with the first witness.
Okay, so I'm going to go put Mr. Cook in his room and I will come back. I have to make sure it's working.
Your Honor, did you want me to swear the witnesses or you're going to swear them?
I'm going to ask you to swear them.
Ms. Crowley, I'm going to send to you right now a link with all of the PDFs of the trial exhibits,
Perfect.
just so that you have them for reference, and then we
Yep.
will FedEx to you a hard copy.
Perfect. Thank you. You have my email address? You have it,
I
right?
do, I
Okay.
do. It is the Yahoo address?
Yes. Yep.
She has.
Oh, okay. Seems that he knows.
I would like to note for the record, Your
Me
Honor,
too.
that Mr. Cook has been in our office for 2 days and apparently knows how to use the technology significantly better than 2 lawyers who have a combined 30 years at this firm.
Is that okay? I can come closer if you want.
Stop showing off, Mr. Cook.
It's okay with me. Let me make sure that the reporter, can you hear him clearly?
I can hear him. Yep. He sounds good to me.
Okay, super. So welcome, Mr. Cook. I'm going to ask the reporter to swear you, and then I'm going to go over some Zoom background materials, okay?
Mr. Cook, would you raise your right hand, please? Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. So, Mr. Cook, I understand I asked your counsel and all counsel in this case to review with the witnesses video conference procedural order. Did you have an opportunity to review that? I hope you have with your counsel.
I did, yes.
Okay, so what I just want to make sure is that you understand that you're alone in this room today. It looks like you are, but you can just confirm that for the record, please.
I am, Your Honor.
And so while you're testifying, there's no private communication, no texting, no email, no hand signals, anything of that nature. So we just want to make sure that we have your testimony coming from yourself today. Is that okay?
That's okay, Your Honor.
Okay, and it looks like you have no notes in front of you, but you do have the 2 exhibit binders. Is that correct?
Yes.
And again, speak up, and you know, the reporter is going to be taking down everything that you say. The one other thing I would mention to you is, in the event that Attorney Marshall has an objection, which he may, he'll just going to raise his hand, and I'm going to hear him on that objection. So if you see something like that happen, just pause and wait until don't answer the question. Just wait until we get to the other side of it, and then we can get your answer at that point in time. Okay? Super. The last thing is, if we take a break, I'm just going to ask you to, I don't know how you're going to mute your screen. We'll figure that out later. Let's get started, and maybe we won't be muting the screen in that room. I have no idea. So let's go. Attorney Berardi or Attorney Long, you're going to examine Mr. Cook?
Yes, Attorney Long is going to examine Mr. Cook. Good morning, Mr. Cook. Could you please state your full name for the record?
Yes, it's Lawrence David Cook.
And where do you live, Mr. Cook?
I live in Middleborough, Massachusetts.
Did you attend college?
I did.
Where did you attend college?
At the University of Portsmouth in England.
Did you receive any degrees?
Yes, I received a Bachelor of Science in Real Estate Management.
Where are you currently employed?
I'm currently employed with AMP Solar.
What is your position with AMP Solar?
I am a Senior Project Manager.
And in your position as a Senior Project Manager, what are your duties and responsibilities?
My duties and responsibilities are to coordinate the construction activities, contract activities in appointing EPCs, budgetary, and in development of new projects as well.
And what is the nature of AMP's business?
AMP is a global energy infrastructure owner, operator, and manager, anchored in solar and more recently in energy storage.
I'm actually having a hard time hearing him.
He's a little bit hard for me too.
Okay.
Yeah.
Let's see if I
I guess,
can-
Ms. Crowley, it's definitely more important for you to make sure that you can hear him.
Yeah, I was just going to ask him to repeat the end of that answer.
Okay.
I
There's
didn't.
there to be a microphone. I can move this a little closer.
And Mr.
Apologies.
You now get to demonstrate your
Technical.
technical skills. Yeah.
I can just talk louder. They might be able to hear me directly without needing the microphone. But is that better at that volume?
It is, but there's like a little muffle sometimes when you start to talk. And I don't know if that's just because you're so far away, but I'm not having it with Attorney Long. I don't know.
Okay. If you don't mind, I'll just rejig the room slightly.
Yep.
Why?
Okay. Is this better?
Yes, much better. Yes.
Okay.
Yes, that's much better. Mr. Cook, I just, just to remind you, and I will try to do it as well, just to talk, purposefully, slowly and clearly, so the court reporter can get everything down, since obviously we have extenuating circumstances here. I'm just going to repeat the question. Is that okay? Mr. Cook, what is the nature of AMP's business?
AMP is a global owner, operator, and developer of renewable energy projects, particularly in solar and more recently in energy storage.
How long have you worked at AMP?
Since 2016.
And have you held the same position as senior project manager since 2016?
Yes, I have.
And have you held any other places of employment in the solar or similar industry?
Yes, since 2010, when I first started working in solar, I was a project manager and development manager in the UK for 2 years prior to moving to America, and then worked for a company called Energy Systems and Installation as a senior project manager in charge of construction and development.
How many solar permitting projects have you been involved in Massachusetts?
In Massachusetts, approximately 13.
And what were your roles in these projects?
They varied. We pick up projects at different parts of the development timeline, whether they've gone into construction or a commercial operation date, or from site concept. So depending on the project, it would depend on when we've picked it up.
And as you know, we are here today with respect to a denial of a special permit by the Wilbraham Planning Board of a large-scale ground-mounted solar energy system to be located at 285 Three Rivers Road in Wilbraham, Massachusetts. Now, were you involved in that project?
Yes, I was.
And who was the applicant for that project?
The applicant in that project was ASD Three Rivers Solar MA LLC.
Who or what is ASD Three Rivers Mass Solar LLC?
ASD Three Rivers is a special purpose entity that is set up by AMP Solar with the sole purpose of coordinating all the related sale of electricity and assets of an eventual solar project.
And can you explain generally what a large-scale ground-mounted solar energy system is?
It is defined in the bylaw how the town view it, but it is a subjective description depending on the size of a project. In my opinion, it would be a project north of 1 megawatt, which would be typically a 5 acre and above project rather than a 10,000 square foot requirement.
And are there different types of solar energy systems?
Yes, there are. There are different types of rooftop installations and 3 primary ground-mounted installations, either fixed tilt, where the modules are set on a rack that doesn't move, or a single-access tracker that moves east-west with the sun, or a dual-access tracker that moves east-west and north-south with the sun at different times of the year.
Now, can you generally walk us through the application process for these large-scale systems in Wilbraham?
Primarily, Massachusetts has requirements to meet renewable energy targets. So Massachusetts is a state that AMP identified as having a need for solar. And once you decide on a state that needs it, you look for available land to actually install them. You identify a piece of land based on its geographical characteristics, the orientation, and whether you can access it, and its proximity to the poles on the road of sufficient size and capacity to take the power that's produced.
And were these the steps taken by ASD Three Rivers with respect to the application?
They were.
That is the subject of this litigation?
They were.
And did anyone from ASD Three Rivers meet with the town or the planning board prior to Three Rivers filing its application for this solar system?
I believe our external consultant, Evan Turner, met with the town prior to submission.
And who does Mr. Turner work for?
He's a sole proprietor of a company that is retained and appointed by AMP to locate and develop solar energy projects within the state of Massachusetts.
So, Mr. Cook, in front of you, you have the exhibit binders.
Yes.
Okay, and I want you to take a look at the exhibit that has been marked, or the document that's been marked as Exhibit 1.
Yes.
And have you seen that exhibit before?
Yes, I have.
Okay, and what is that exhibit?
This exhibit is the application, or the initial application to the town for the proposed development.
And what date was this application submitted to the town?
August 27, 2018.
And what do you mean when you say it was the initial application that was submitted?
So there were several revisions that happened after the application was submitted. At the time that this application was submitted, we were still working with the town and the Conservation Commission, and we submitted revised plans at various different times to incorporate various different stakeholders, like the Planning Board, Conservation Commission, and the town engineer. Their comments.
Explain the process by which ASD compiled this application.
So once we've located the site, we refer to the town's published bylaws, specifically relating, generally and specifically relating to solar, and we make sure that we are submitting all of the relevant design and standard criteria listed within the bylaw.
Your Honor, I'm sorry.
Yeah.
I'm having trouble with my video. I don't know if I hit something. I'm sorry.
No, that's okay. Thank you for letting us know.
Was it when the document share came up, Alan?
Yeah, maybe. Sorry.
Can you not see us now? Is that what's going on? And
I can, but so all of you are in a strip on the right side, and I got the document here. I was just trying to see.
Yeah, Attorney Marshall, that's a result of how you have the Zoom view set up. Because we are sharing an exhibit, it will take up the bulk of the screen.
Okay.
can you see, and you see at the top of the left-hand corner, there's a little box, there's some options with different icons, so you can say who you can hide, you can show just the active speaker, you can you want to just click on those so you can see. I was just doing that myself. See what your options are in terms of, because I want to make sure you can see me, and you want to be able to make sure you can see the witness during all this, right?
Yeah, I'm sorry. It got distracting, and I wasn't.
Yeah, no, let's take the time to figure it out. That's what we're trying to do today. We're all figuring this out today.
Your Honor, I don't know if it's easier for you to have the screen share. I mean, since we all have the exhibits in front of us, if we remove it and it fixes this problem, I mean, really the only time I think I would anticipate wanting the share screen is when we're using deposition testimony for impeachment with Mr.
Okay.
Pierce. So I mean, if it works for you, we can just take it off and then his screen can go back and we can move forward.
Yeah, I think let's do that. Let's try to have the screen share, and certainly if there's a particular portion of the exhibit that you want to focus on, we can bring it back up again. Okay, so but I will grab my exhibits because they're right here. Okay. Attorney Marshall, do you have your exhibit binders there, and witness, you also have your exhibit binders?
Oh,
Yep.
I think that'll be a great solution, at least for me. Thank you.
Okay.
Okay, so we're all set now. It's
Exhibit 1.
okay.
Yep.
Mr. Cook, did you complete your answer to the last question?
I did, yes.
Okay. Now, Mr. Cook, again, we're still on Exhibit 1. If you turn to the second page, there's a table of contents.
Yes.
And in the table of contents, there's numerous documents listed.
Yes.
And does this initial application that has been marked as Exhibit 1 include all of those documents listed in the table of contents?
It does.
And you had testified earlier that throughout the application process, ASD had submitted additional documents after August 27th, 2018, correct?
That's correct.
Now, if you turn to Exhibit 3 in your trial binder.
Yes.
Hold on, I got to catch up with you. Okay? Okay, I got it.
Now, looking at Mr. Cook, looking at Exhibit 3, have you seen that document before?
Yes, I have.
And what is that document?
It is the formal written denial for our special permits.
And when you say our special permit, you mean
For
the-
ASD, Three Rivers.
And again, still on Exhibit 3, looking at the first 2 pages of Exhibit 3, it lists various documents.
Yes,
Are those all the documents submitted by ASD Three Rivers throughout the entire application process?
it appears complete, yes.
Now, back to Exhibit 1. With respect to your application for this process, was ASD required to submit a building coverage calculation pursuant to section 4.4 and 4.4.10 of the Wilbraham bylaw?
We were not.
Have you ever been required to submit a building coverage calculation for any other permit for a similar project in Massachusetts?
I have not.
What about anywhere else in the United States?
No, I have not.
Okay, Mr. Cook, how many hearings did the planning board hold on this particular application?
There were 3 hearings.
And do you recall when the first hearing took place?
The first hearing took place on the 10th of October, 2018.
And were you in attendance at that hearing?
Yes, I was.
Who else from ASD Three Rivers was in attendance at that hearing?
Mr. Evan Turner, a colleague of mine at AMP, Luke Ricard, and the project manager for the consultant engineering firm, Jeff Brandt.
Now, looking at Exhibit 1, which was, you testified was filed with the town on August 27th, 2018. Between August 27th, 2018 and the date of the first hearing, which was August 10th, 2018,
October 10th.
October 10th, 2018, did ASD make any further submissions to the town or the planning board in support of its application?
Yes, we did. We submitted a revised plan, large-scale plan set for the board to review, which included additional landscape features and incorporated the comments from the Conservation Commission.
Okay, so let's take a look at Exhibit 4. I apologize, these binders are very cumbersome.
I have Exhibit 4 open.
Your Honor, maybe a good way to do it is sort of like a deposition, just to have everyone look up when they found their exhibit. Attorney Marshall, just so I know, because I know it can take a long time to flip through these pages. So Attorney Marshall, you all set?
Yes.
Yeah, okay.
Thank you.
So Mr. Cook, looking at exhibit number 4, are those the materials that you are referring to?
They are.
And looking at the first page of exhibit 4, which is a letter dated September 13th, 2018, do you see that?
Yes, I do.
And it's in the author, who is the author of that letter?
That is Jeff Brandt.
And who is Jeff Brandt?
Jeff Brandt is the project manager for TRC, who are the external engineering consultants that were appointed by AMP to assist with the application.
And attached to that letter, if you turn to the second page of exhibit 4, there are plans titled Permitting Site Plan dated September 12th, 2018.
Yes.
Are those the plans that Mr. Brandt submitted to Mr. Pearsall?
They are.
And what revisions and or additions did those plans portray?
So, as previously mentioned, at the time that we submitted, we were still discussing things with the Conservation Commission, and we incorporated their comments into this plan.
When you say they, you mean?
The TRC.
And what comments were received from the Conservation Commission?
I believe it was to do with wetland. Well, they primarily to do with the wetland. I think there was a stormwater basin that was adjusted. And the other thing was that on our initial application, when we put the 50-foot setbacks and we were going to retain them as woodland, we believed that that would supply sufficient screening. But after further consideration, we proposed some additional screening to the setbacks as well.
So let's take a look at exhibit number 5. Have you seen exhibit number 5 before?
Yes, I have.
And that, Attorney Marshall, you all set?
Yes.
Okay. And exhibit number 5 is a letter dated October 8th, 2018
Yes,
from Jeff Brandt to Mr. Pearsall.
it is.
And was this submitted to Mr. Pearsall prior to the first hearing?
It was.
And what was included in this submission to Mr. Pearsall?
There were some additional landscaping plans that were submitted, a noise study report, and correction for the size of the outlet in one of the detention basins.
And with respect to the landscaping plans, were they changes to the original plan?
Yes, the original plan that was submitted was going to use the retained woodland and shrubbery around the array, primarily as the screening. This specified species and the additional screening that we were proposing. And
what type of additional screening were you proposing?
We were proposing a varied amount of different trees and shrubs to shield the array year-round from any abutters.
And why did Mr. Brandt make these 2 submissions dated September 13th and October 10th to the board?
I believe it was at the request of Mr. Pearsall for some additional information that the board would require.
Now, I believe you recalled the first hearing took place on October 10th, 2018, correct?
That's correct.
Besides who you already identified was present on behalf of ASD, who actually spoke at the hearing on behalf of ASD?
The lead was Mr. Evan Turner, and both myself and Luke answered questions to the board about things that were raised during the meeting. And
what was Mr. Turner's role as far as presenting to the board?
It was to present our application and to go through in its completeness and provide any additional, find out if there's any additional information required and to answer any questions and clarifications on the documents that were submitted.
Did any member of the planning board speak at this first hearing?
Yes, they did.
And do you recall who spoke?
They all spoke. They all had different questions relating to the application.
And were those questions responded to by ASD?
They were.
And do you recall the nature of those questions?
Just general questions concerning the size, the setbacks, and just anything that was not initially clear in our application.
Did the board or anyone else at this first hearing mention a building coverage calculation needed to be done?
They did not.
Did anyone at this meeting mention that the building coverage calculation applied?
They did not.
What happened at the end of the first hearing?
It was continued pending a site visit with members of the board and any members of the public that wish to attend.
And did the board schedule the site view?
They did.
Now, do you recall the date of the second hearing?
Yes, it was October 24th, 2018.
And between the time the first hearing ended on October 10th and the second hearing took place on October 24th, did ASD 3 Rivers make any additional submissions to the town or the planning board?
Yes, we did.
So just proceeding along in the binder, let's move along to Exhibit 6. have you seen Exhibit 6 before, Mr. Cook?
Yes, I have.
And that is a letter from Jeff Brandt, again, to the Wilbraham Planning Board dated October 23rd, 2018, correct?
Correct.
And what did this submission to the planning board include?
This submission to the planning board included a wildlife habitat evaluation, and it also included some revised plans.
And what was the nature of the revised plans?
The nature of the revised plans had the effect of increasing the amount of open space that was on site by increasing the setbacks from the surrounding property lines and reducing the overall size of the array, of the solar project.
So let's now move to Exhibit 7.
Yes.
And Exhibit 7 is a permitting site plan dated October 24th, 2018. Do you see that?
I do.
Was this something that was also submitted to the town?
It was.
Okay. And was this in conjunction with Exhibit 6?
It was.
Okay. And what do the plans in Exhibit 7 show, add, or revise with respect to the existing application?
So the initial application was submitted with the minimum setbacks within the bylaw of 50 feet from surrounding property lines. These revised plans increase those setbacks to 85 foot and 100 foot. And we reduced the size of the array by about 10 or 12%. And there was also a minor modification on the stormwater basin to increase the size of an outlet pipe following a response from the town engineer.
So you decreased the size of the array, but increased the setbacks, correct?
Correct, yes.
Could you explain the relationship between the footprint of the array and the setbacks?
So obviously the setback is the distance from the property lines. And so when you move the setback further away, you reduce the footprint area that the solar system is going to take up on the ground. And in conjunction with the reduction in solar panels and size of the system, we increased the amount of open space.
Now, you had testified earlier that at the end of the first hearing, the planning board scheduled a site view, correct?
Correct.
And when did that site view take place, if you recall?
It was on the day of the hearing, October 24th, 2018.
Who attended from ASD?
Myself, Evan Turner, and Luke Rickard.
And who else attended from the planning board?
The planning chair, a lady on the planning board, I believe her name is Tracy. I think there was another member or two from the planning board. It wasn't the full planning board, and there were several members of the public.
Did Mr. Pearsall attend that site view, if you recall?
I don't recall, but I believe he did, yes.
And did any abutters attend the site view?
Yes, there were.
Approximately how many?
There was approximately 12 to 18 people in total. If you take out ASD and the planning board, that would leave approximately 8 to 10 members of the public.
Now, could you just briefly walk through what occurred at this site visit?
We entered the site. There is a car path around the internal of the site, which we primarily followed to get to the kind of four corners of the array, trying to follow the approximate fence line and outline of where the array was. Just generally answer any questions that arose.
Did the planning board specifically ask you to point anything out at this site view?
Not specifically. We led the site view and pointed out all the relevant structures due to our familiarity with the site.
Did any abutters specifically ask you to point anything out at the site view?
When we approached the southeast corner, there was an abutter that was in his yard area, and he entered the site from his yard and asked us to locate the corner of the array as he would see it.
Did any other abutters ask you specifically to point out anything?
No.
Okay. And was a mock-up done showing the height of their array?
There was a mock-up done in a couple of locations, yes.
Well, hold on. Am I understanding that at the time of the site visit, there was a mock-up?
Yes, Evan Turner it showed or sort of put a tarp up the approximate height and the approximate location of where the array would be, so that anybody who could stand on the property line and see if it was visible.
Was it around the whole perimeter of the
It
array?
wasn't around the perimeter. It was in two of the corners.
So who prepared and presented this mock-up?
That was Evan Turner.
And that was done on behalf of ASD?
That was.
Now, going back to Exhibit 7. Now, I believe you testified that Exhibit 7, these were the October 24th, 2018 permitting site plans?
They are, yes.
Okay, and during this site view, did you walk through the revisions shown on this plan?
Yes, we did.
Okay, and I believe you testified before that that plan showed a decrease in the size of the project as well as an increase in the setbacks of the project?
That's correct, yes.
And did this Exhibit 7 show anything with respect to changes to the landscaping plan?
It did. It gave a lot more detail of the proposed species, and it was also enhanced in certain areas where it was thought that there may be some additional screening that could be required.
And when did this second hearing take place?
That was the evening after the site visit on October 24, 2018.
Who from ASD attended the second hearing?
Myself, Luke Ricard, Evan Turner, and our consultant, Jeff Randigan.
And what did ASD present at this second hearing?
We presented the revised plans and had discussions.
And when you say revised plans, are you referring to the plans that are marked as Exhibit 7?
I am, yes.
Now, can we flip back to Exhibit 3, which is the decision? I'm sorry, this is probably going to take a while to flip back.
Okay. Yep.
Mr. Marshall, you all set?
No, 1 second, sorry.
Just as an administrative
Got it.
thought, I printed out copies of the decision to keep separately since we're are always referring to it. And by the time we get to, Exhibit 21 or 22, it's going to be really hard to flip back to Exhibit 3. So,
Well, maybe I'll take it out of my binder
yeah.
and I can put it back in again when we're done. I'm not doing that with everything.
That's fair, Your Honor.
Mr. Cook, are you on Exhibit 3 of the decision?
Yes.
Okay. Now, turning to the decision, page 4. Actually, page 3. And if you see, there's a paragraph 6 at the top of page 3.
Yes.
Okay. And that paragraph is discussing the October 24th, 2018 hearing. Do you see that?
I do.
Okay. And if you want to just take a minute to read that paragraph.
Okay.
Okay.
Well,
And
let me read it, okay?
oh, sure.
Never mind, just as long as, I might as well follow along with everybody.
Okay, you'd like me to read it?
Sure.
Would you like, sure, you want to read it? Go ahead. Yep.
On October 24th, 2018, the planning board reopened the public hearing, at which time the applicant presented revised plans that showed some minor setback distance adjustments and a modest reduction into the footprint area of the proposed solar array, and where additional opportunity was given to all those interested to be heard in favour of or in opposition to said application. With the consent of the applicant, the public hearing was continued to November 14th, 2018, in order to give the applicant more time to provide additional information and to address the concerns raised at the public hearing.
Now, Mr. Cook, is it your understanding that the revised plans mentioned in paragraph 6 are the revised plans that we are talking about in Exhibit 7?
They are.
And do you agree or disagree with the board's characterization that minor setback distance adjustments were shown and a modest reduction to the footprint area was shown?
I do not agree with that.
And why don't you agree with that characterization?
The use of the word modest would suggest it was small or minor, and we'd increase the setback substantially and reduce the array, the size of the array substantially at that time as well. In both cases, between 12 and 18%.
And did the setback shown in the original plan that you submitted on August 27 comply with the minimum requirements of the bylaw?
They did.
And then therefore did the increased setback shown in Exhibit 7 on the October 24th, 2018 plan, did those setbacks comply with the minimum requirements of the bylaw?
They were well in excess, in one case more than double.
Did ASD discuss these changes in the setback at this hearing?
Yes, we did.
And what did ASD discuss?
So we primarily discussed the fact that we'd moved them away from the side. We also had a long discussion over whether the town would like to see some form of footpath around the array so that people could walk dogs and things like that, because there was going to be a space between the security fence and the limited tree clearing, and we could have used that area for local recreation. So that we had a lot of discussion on that, as well as the overall plans and reductions in size.
Okay, so you said you discussed the reduction in size, the setbacks, the footpaths. Was the landscaping discussed at this hearing?
It was.
And what was discussed?
Just that we were going above and beyond the requirements in the bylaw to provide additional landscaping on all boundaries.
And were these landscaping additions and or revisions shown on Exhibit 7?
They were.
Did any abutters speak at this hearing?
Yes.
And do you recall the nature of the testimony?
General opposition and just wanting more information over the proposal.
And what type of information were they looking for, if you recall?
I don't recall specifically. It just height of panels, glare, noise, that kind of thing.
Did anyone from the planning board speak at the second hearing?
Yes, they did.
And do you recall what they spoke about?
The same general questions, yeah, just the same general questions about our proposed reduction and the landscaping.
Now, did the board or anyone else at this second hearing mention a building coverage calculation needed to be performed?
They did not.
Did anyone at this hearing mention that the building coverage calculation even applied?
They did not.
What happened at the end of this hearing?
The meeting was continued until the next meeting in November.
Now, do you recall when the meeting in November took place?
That was November 14th, 2018.
And between the time the second hearing was continued and the third hearing took place, did ASD make any additional submissions to the board?
Yes, we did.
Let's turn to Exhibit 8 of the binder. Now looking at Exhibit 8, have you seen that document before?
Yes, I have.
And that's another letter from Jeff Brandt to Mr. Pearsall dated November 5th, 2018, correct?
That's correct.
And was this the submission you were referring to?
It was.
Okay. And what does this submission include?
This submission includes some revised plans again, following on from the comments of the previous hearing. It appears an edit to the plans indicating a 36-inch culvert outfall for the basin.
So if we flip the cover letter on Exhibit 8 and go to the first page.
Yep.
What is that?
That is a line of sight diagram prepared by TRC.
And why was that prepared?
One of the abutters that spoke at the hearing was concerned that he would have a view of the array from his property.
And what does, I'm sorry, go ahead.
No, because the board requested that prior to the next hearing that we would provide a line of sight diagram to show the impact.
And what does this diagram show as far as impact?
It shows that from a second floor window, there would be a portion of the array that would be visible, a small portion of the array that could be visible at the high point, but most of the array would be invisible to the abutter.
And when you say small portion, can you quantify that a little more?
No more than 10%, closer to 5.
Can we spend a little bit more time on this, Attorney Long? If you're planning on doing it, please proceed, but I don't know how to read this document. And if I need to, it would be good to spend some time with it.
Sure,
Okay.
Mr. Cook, could you walk through how you read and interpret this sightline analysis?
Yes.
Step-by-step process?
Step by step. But if we start on the far left, it highlights the observer location at the approximate height of the house. There are then 2 dotted lines that extend from that observer location. The first line passes through, goes over 3 Rivers Road, which is marked, and it shows the vegetation that exists at the site already at the street, which has been taken from LiDAR. Which is an aerial radar to get the heights. And it shows that lower sight line passes through the trees, which in effect shows that lower portion of the array is invisible. The upper line is the unobstructed view when it passes that vegetation and follows to the point of the array which it can see.
So hold on. So there's 2 different dotted lines coming out of the little house, right?
So the top line is the line that follows that would clear the vegetation at the street. So that the line across the bottom is the distance from the observer point. At approximately 180 feet, you can see that there is a landscape area. Those are the existing trees that exist within the wetland and at the site boundary. So that first dotted line clearly goes through that area, which shows that line of sight terminates at the trees. That top line, the dotted line, is the line that would clear the top of the vegetation, and that follows to approximately 1,350 feet away. Where it would actually meet in line with the array. So that portion would be the part that was visible. And as you can see, it clearly shows just the top of the array.
And this is from one particular location.
This is from the abutter, the specific location that the board requested this line of sight to come from.
Okay, thank you.
You're welcome.
Mr. Cook, do you recall the address of the abutter who this was done for?
I do not.
Do you recall the name of the abutter this was done for?
He identified himself as Victor. I can't remember his last name.
Okay, still on exhibit number 8, if you go to the next page, there's a November 1st, 2018 permitting site plan. Could you tell us what this plan showed?
So following on from the discussions at the previous meeting, where the view was the primary concern from the abutting neighbours, we proposed some further landscaping enhancements, which included the installation of a 10-foot high wooden fence along an earthen berm, which would have the effect of almost totally screening the array from the abutters. And we also increased the setbacks, again, substantially from those abutting properties, as well as a further reduction in the array size.
Okay, when you say increase the setbacks, can you tell us by how much and what was done?
Yes, so the original submission was in accordance with the bylaw, 50 feet. This revised submission had the minimum setback at 100 foot, so double the minimum requirement on two sides, and 150 foot to the south, where the neighbours were most concerned.
And did this plan show any revisions in the size of the proposed array?
It did. We reduced the size of the array by a further approximately 10%, which was around 25% lower than the original submission.
Now I'm just turning back to Mr. Brandt's cover letter, which is the first page of the Exhibit 8.
Yes.
Okay. And the second bullet point indicates that the modifications include a 9 to 10 foot high wood fence and a 2-foot high berm to block views from neighboring areas.
Yes.
Can you explain what these modifications were?
So this fence was in addition to the security fence that was proposed to go around the array. This was a fence that was more in keeping with the residential nature, as we felt that a chain link security fence would not be the most attractive thing to look at, though allowable within the bylaw. So we proposed more residential style fencing to protect the views of the neighbouring properties. So a 9 to 10 foot high fence on top of a 2-foot high berm would make the fence approximately 11 to 13 feet high. And that would be 150 feet away from the neighbours to the south.
So is the berm supposed to go all the way around the property with the fence on top?
So yeah, so the berm raises up 2 feet, and then there's the fence on top.
And did the bylaw have any requirements for fencing?
Not explicitly, it's in the security. You have to have a fence as part of the electric code to secure the site. So the general requirement is the security fencing is sufficient.
And
so this proposed fence was in addition to the minimum requirements.
Now, in addition to what you've already discussed with respect to this November 1st, 2018 plan with the landscaping, were there any other additional modifications made or enhancements to the landscaping that you haven't told us?
No, as I said, the just more detail specified species to ensure that the entire array was shielded is more than economically practical at the time.
Now, I believe you testified the third hearing took place on November 14th, 2018, correct?
Sorry, could you repeat that?
The third hearing date took place on November 14th, 2018?
That's correct.
Who attended on behalf of ASD?
Myself, Evan Turner, and Luke Ricard, and Jeff Brandt.
Did Mr. Pearsall attend this meeting?
I believe he did.
Who spoke on behalf of ASD at this meeting?
Again, it was primarily Evan Turner with additional questions being answered by myself and Luke Ricard.
And what did ASD present at this hearing?
We presented the final set of plans, which showed all of the ways that we were going above and beyond the minimum requirements in the bylaw, with the additional fencing and the additional setbacks that we were proposing, and the reduction in the array.
And when you say additional plans, are you referring to that November 1st, 2018 plan we were just discussing?
I am indeed.
Did any abutters speak at this meeting?
Yes,
And what was the nature of their testimony?
they appreciated the additional length that we were going to, but they were still objecting to the project.
On what grounds?
It was just that they didn't want to have a solar farm in that area.
Did any members of the planning board speak at this third hearing?
Yes, they did.
And what was the nature of their testimony?
Again, they were just asking for further clarifications and what we were proposing. But yeah, nothing more than that.
Did any planning board members at this third hearing speak whether they were in opposition or approval of the project at this time?
I don't recall.
Did the board or anyone else at this hearing, third hearing, ever mention a building coverage calculation needed to be done?
No.
Did anyone at this meeting ever mention that the building coverage calculation applied?
No, they did not.
At this point in time, which was November 14th, 2018, had ASD Three Rivers ever performed a building coverage calculation for
No,
the site?
We had not.
Why not?
It just wasn't even on our radar. A read through of the relevant section in the bylaw, it would not indicate that it applied. We've never had to do it before, and so it just didn't enter our thinking.
And what happened at the end of this hearing?
We asked the board whether there was any further information that they needed at this time or anything further we could do. They responded that there wasn't, and so the meeting was closed.
Did the board express their opinion on whether they were going to allow or deny the permit at this time?
They didn't express an opinion, though, but the general sense that was obvious was that there was a more than likely chance that they would refuse.
I'm sorry, I didn't hear the last. Did you hear?
Just the general demeanor of the board at the time.
Did the hearing then close?
The hearing then closed.
And there were no more continuances?
No more continuances.
Now, let's go all the way back to Exhibit 2, which is the bylaw. And just specifically so I can give you the right page, we're going to look at section 10.7, which is actually on page 10-12 of that bylaw. Now, Mr. Cook, looking at Exhibit 2, which is a copy of the zoning bylaw of the town of Wilbraham. Have you seen that bylaw before?
Yes, I have.
And what version of this of the bylaw is this?
This is the revision dated August 2018.
And was this the applicable version with respect to the ASD Three Rivers project?
It was.
All right. Now, sorry, going back to section 10.7 of the bylaw. What does section 10.7 of this bylaw refer to?
The design standards required for large-scale ground-mounted solar energy systems within the town of Wilbraham.
Okay, when you said design standards, are you actually referring to section 10.7.7?
Just the general requirements and the applicability, yeah.
And what does section 10.7 of the bylaw generally refer to?
10.7 is the general purpose, applicability, and the general requirements for solar.
And then looking at 10.7.7, which is on page 10-14, that refers to the design requirements and performance standards for these systems, correct?
That does.
Okay, so we're going to stay on 10.7.7 for a little bit. Looking at the design requirements and performance standards, section or paragraph A says lot size. Did ASD Three Rivers meet the minimum lot size?
We did, substantially so. We were a little over 20 acres rather than 5 acres.
Looking at paragraph B of 10.7.7 setbacks.
Yes.
Did the ASD Three River project meet the minimum requirement for setbacks with respect to this project?
Yes, significantly above and beyond. The minimum setback requirement is 50 feet, and we were minimally 100 feet away at the final submission.
Looking at paragraph C of this section, did the ASD Three River project comply with the minimum height requirements?
We did. Our proposed maximum height was 9 feet, and 15 feet is listed as the maximum height.
I shouldn't have said minimum height requirements. Looking at paragraph D, appurtenant structures, did the ASD Three River project comply with that section?
Yes, we did.
And what did that section require?
That the appurtenant structures should be architecturally compatible with each other and the reasonable regulations concerning the bulk.
Looking at section E, paragraph E of that section, I'm sorry, lighting.
Yes.
Did the ASD Three River project comply with that section?
Yes, we did. We did not propose any lighting on site.
Looking at section F, screening. Did the ASD Three Rivers project comply with the screening requirements of the bylaw?
Yes, we did. We were the screening would have had the first 100 to 150 foot of the existing woodland, and then the berm, the fence, then the planting, then the security fence.
Looking at paragraph G of this section, vegetation clearing. Did the ASD Three Rivers project comply with this section?
Yes, it did.
How so?
We were only going to clear the vegetation that was required for the array, plus potentially some selected clearing within the setback zone due to shading.
Looking at paragraph H, habitat fragmentation. Did the project comply with this section?
Yes, we did. Obviously, in support of that, we had the wildlife habitat survey carried out. We also proposed to seed the meadow with wildflowers to increase biodiversity within the area.
Looking at paragraph I, signs. Did the project comply with this section?
Yes, the application included security fencing around the array to alert of the dangers, plus a sign with the operations and maintenance and emergency contact details.
Section J, noise. Did the project comply with this section?
Yes, it did. As part of the documents that were submitted in support of our application was a noise survey, and it showed that we were meeting or exceeding all the applicable state and local codes.
Section K, utility connections. Did the project comply with section K?
Yes, it did, and our application was included in the first application.
Section L, oh, I'm sorry, do you want to add anything to K?
The application for the interconnection was included in the first application to the planning board. I just wanted to clarify application.
Paragraph L, stormwater management. Did the project comply with this?
Yes, it did, and we'd had back and forth throughout this process with the town engineer and made any incorporated any comments they had.
And when you say town engineer, who are you referring to?
Ed Meager.
Looking at paragraph M, security measures. Did the project comply with that?
Yes, we proposed a security fence with a single point of entry around the site.
Paragraph N, emergency access. Did the project comply with that?
Yes, we did. The emergency access was proposed through a Knox box, which is a box that gets mounted on the fence that the emergency services have access to give them access into the site.
And lastly, section O, emergency response plan. Was that complied with?
That was complied with. We submitted an operations and maintenance plan, and we included some narrative. Once the system went into its final design with the final components identified and specified, we would have to formulate that plan at that point because a different battery container would have a different requirement than another one. But our general willingness to train and explain what was on site with the local emergency services.
Now let's turn all the way back to section 4.4.4 of the bylaw, which is on page 4-2. And this is still exhibit 2.
On page 4.4.
4-2, yes. Okay, Mr. Cook, looking at section 4.4.4, maximum building coverage. When is the first time you found out that the building coverage provision of this section, which refers to section 4.4.10, was going to be applied by the board with respect to this particular project?
Not until we received the written decision in January.
Did Three Rivers ever consider this provision as part of its application prior to the decision?
No. Why
not?
We had multiple discussions with the board about reducing the size of the array. At no point did they raise it as something we would need to be mindful of. Wasn't anything we considered.
When you received the decision, did you know how actually, you know what, let's refer back to the decision. So
Exhibit 3.
which is exhibit 3. Okay, I'm on the decision exhibit 3. Turn to page 4 and take a look at paragraph 13.
Yes. Would you like me to read it out again, Your Honor?
That would be lovely. Thank you.
The submitted design of the proposed use will result in a solar array with a total footprint area of approximately 10.4 acres, which represents approximately 48% of the total area of the subject property, and which would significantly exceed the maximum building coverage requirement of 20% in the residential R60 zoning district imposed under section 4.4.8 of the Wilbraham zoning bylaw.
Now, Mr. Cook, I believe you said 20%, but I believe paragraph 13 says 25%.
25%, apologies.
Okay. Now, when you received the decision and saw paragraph 13, did you know how the board reached this 48% building coverage figure?
Not exactly, no.
When did ASD Three Rivers first find out how the town was calculating building coverage?
Not until we were in mediation in June of 2019.
When did you receive the exact methodology the town was using to calculate building coverage?
Not until the town provided the discovery documents as part of this trial.
Okay, and when you say discovery documents, let's turn to exhibit 23.
On 2 seconds. Yep.
And I believe is exhibit 23 the first in
It's the first exhibit in volume 2.
in volume 2, so.
Hold on. Okay, which exhibit am I on? 23?
53, Your Honor. It's
Thank
the
you.
first exhibit of volume 2, much less page turning.
True.
Now, Mr. Cook, when you mentioned the discovery from the town, is exhibit 23 the discovery you were referring to?
It is.
Okay, and if you churn, there's an attachment, actually in exhibit A to defendant's answers to first set of interrogatories. Do you see that?
I do.
And what does exhibit A show?
It shows method 1 calculation for the aggregate building footprint area, a table comparing the other solar projects within the town of Wilbraham. It then shows method 2, which is a changed way of calculating the aggregate building footprint area, and then specifically our application and the project at 126B BB Road.
In which method is the town now using to calculate building coverage based on your understanding?
Method 2.
And when is the first time Three Rivers calculated the building coverage under method 2?
Once we saw the exact way that they were working it out.
And when was that?
That would have been after the mediation in the fall of 2019.
No, with respect to method 2, when is the first time ASD Three Rivers calculated the building coverage using method 2?
It would have been when we received the interrogatory.
Okay, and what is the date of these interrogatories? That would be page 7.
The 15th day of July, sorry, the 15th day of July, 2020.
And when ASD Three Rivers calculated this building coverage using method 2, what was the result?
That we were under the 25%.
Did you personally perform these calculations?
I didn't personally until they'd already been calculated by our engineer and Jared Donald, and I ran a sanity check calculation to confirm that they were correct.
One more question, Mr. Cook. I've been referring to it as building coverage, and it places in the decision exhibit 3, it refers to lot coverage. Are those one and the same?
Yes, they're different ways of essentially saying the same thing. The building coverage is the measurement of one, and lot coverage is the measurement of another. They both arrive at the same point.
That's all I have for Mr. Cook.
Thank you. Attorney Marshall, do you have any questions on cross-examination?
I do. Your Honor, maybe we take just a very brief recess. I'll come
Yeah.
back to my cross.
Yep, sure. So let's see, what time is it now? It's 11:37. So can we be back here at 11:45, something like that? Or do folks want until, 11:50, something like that?
No, Your Honor, I think 11:45 is sufficient.
I appreciate 11:50.
Okay, let's do 11:50. And while you're all gone, remember what we're going to do with we're going to go down to the bottom left-hand screen and we're going to mute ourselves. And then we're going to put the stop video on and we'll be back at 11:50, okay?